So you're all very welcome to the webinar. And what we're going to do is, this is going to be recorded, so people will be able to watch it forever and ever. And it's a first of its kind. And the idea behind it is that really myself and Mitra were speaking, and Mitra will introduce herself in a moment. And we were realizing that a lot of detransitioners, and you educated me really, Mitra, and we realized that detransitioners might explore their legal possibilities with one lawyer, maybe get a negative reaction and think that's the end of that, rather than realizing, as you said, they should be lawyer shopping and figuring out, their potentials. And so for that reason, we decided to run this webinar. So first of all, I'm going to introduce Lynn, and Lynn's going to tell everybody about Themis. And then I'll introduce Mitra, who's a lawyer who has a slideshow prepared. And after the slideshow, we're going to go through the questions that were already submitted. And if you have your own question, you can put it into the Q&A live. And like I say, it will be all recorded. So if you have to leave early, it doesn't matter. You will be able to get it later on because we'll send it to everybody. So Lynn, could you first of all introduce yourself and tell us about Themis?
Well, sure. So first of all, let me just say that there is no financial or court settlement that will ever compensate any one of you for what you have so cruelly lost. And I am very sorry that each one of you are here and listening to this. And I am not an attorney, and so I'm very grateful for Mitra's presence here today. And I have been so privileged to get to know Mitra, and I have learned so much from her, particularly about the difficulty of successfully getting a case to trial and winning judgment. So, a bit over a year ago, I began to consider starting a charity to help in the cause of transition litigation. I truly believe that the only way to change the landscape of destruction, that is the affirmative model in the US and elsewhere, is through legal accountability. And I want every therapist, prescribing physician, general practice physician, and surgeon to lie awake at night wondering when they will be sued and hopefully prosecuted. I want them to look into every one of their patients' eyes, wondering if this is the person who will sue them for millions of dollars. I want every one of you to have that satisfaction. I want them to leave young gay and lesbian people alone. I asked some attorneys who are taking detrans cases, would it help if you had a bit of money to cover expenses? Yes, they said. Even an attorney who's willing to work low bono or pro bono in order to represent you, it will cost maybe $200,000 to bring a case to jury trial. There are expenses like court cases and expert witnesses that have to be paid, whether the case is successful or not. Attorneys are actually people who also have to buy groceries like the rest of us. So they can't take a full load of these cases, and they're taking a huge professional risk in the environment that we live in today. So, yes, funding is vitally important. In fact, if we don't fund this, it won't happen. Connecting attorneys with one another, networking, and helping one another will ultimately increase the chances that any of us will be successful. Themis is working to find more attorneys who are both willing to take these cases and qualified to represent them well. We are building a list of attorneys on our website, and we wish there were more. We believe that the social environment is beginning to shift somewhat, and more attorneys will begin to come forward. It will be so helpful to all if we can learn from one another in this emerging and challenging field. Other supportive people that we work to connect are expert witnesses and medical records reviewers. Our mission at Themis is to help all of you as you consider your decision and move forward in the process of litigation. We recognize that litigation, particularly in this area, is extremely stressful and carries a risk of re-traumatizing people who are in the process of healing from extremely traumatizing events. We are interested in you as a person, and we want to prioritize your well-being. Litigation is intrusive. It can go on for a long time. It can be delayed endlessly by procedural issues, and at this time, the chances of a successful outcome are not what we all hoped they would be. We could be in for a much longer battle than we would like to be in, but every one of you, whether your case is individually successful or not, are playing an important role in that battle. Your time is now. You may be on the early end of a long line, or perhaps we will experience a success we're all hoping for. But in any case, you are also very brave to put yourselves out there and go through this process. And we just really want to support you all.
Thanks very much. And what is the process? What should somebody do if they want to contact Themis?
Oh, so we have a website. It's themisresourcefund.org. And on the website we have several sections. So there's a list of attorneys that are actively taking cases. They are all U.S. attorneys. Right now, we care, we care obviously about detransitioners all over the world. But in order to accomplish something, I'm a firm believer that if you want to get something done, you've got to pick something doable. And you can only, do something and then we can do more, right? So we're starting in the US. Um, Also, I think it's important because the US is so difficult. So if we can get something done in the US, it's going to happen everywhere, right? So there's a list of attorneys, and then we have an application process that involves your attorney and yourself submitting an application together. And so we're both trying to figure out whether your attorney is whether we think you have a winnable case and whether we feel that your attorney is qualified to bring the case before we're going to send them money. And we also want to know whether you're really prepared for this realistically. And so the application is reviewed by our committee, which is composed of an attorney and a therapist. So we're looking at both sides, your side, the attorney's side, and then evaluating. And then after that, if we determine that we feel that we can actually help you to accomplish something that will be good for you, then we submit funds. So that's
Brilliant.
our process.
So it's
Yeah.
Themis Resource Fund, and Beyond Trans will always be happy to tell you more. If anybody emails us, we can introduce you, or you can go straight to Themis Resource Fund. Now, thank you very much, Lynn. Now we'll go on to Mitra, who has prepared a slideshow. Thank you very much, Mitra. Would you like to introduce yourself first of all, and then unmute yourself, and then do your slideshow?
Well, hello, everyone. Thank you, Lynn and Stella, for the kind words you had about me. I'm a US lawyer. I have worked in the international field. So I have some familiarity with the civil law system, which is quite different from the common law system. But there are general principles of law that are common to all legal systems. So I think that you still will have some takeaway from this presentation, even if you're in a civil law system, and I will try to point out some of the differences. I cannot give you any type of specific advice about specific jurisdictions. So as I said, I worked in the international field, so my background is in international law and international human rights law specifically. And I practice in the US. I'm an American lawyer, and that is really sort of my main area of practice. But I think that we as a group of concerned people, as well as lawyers, and you as people who have been harmed by gender affirming care, have human rights. So this is not just a medical malpractice issue. This is a human rights issue. As I'm sure all of you are aware, trans rights activists assert it as a human rights, but there is human rights on the other side as well, because all rights have limitations, and when one person's right crosses over into another person's right, it creates a conflict, and that is what we have. They want to have no barriers, but barriers are necessary to protect others. So, and I think these arguments actually in the civil law system, if you find the right lawyer, I'd like to think that you can have more success with some of these issues in Europe because you can eventually appeal to the European Court of Human Rights, which is, the jurisprudence is so well informed of various human rights elements. So don't just consider this a medical issue, medical negligence issue. Bad medicine is not just negligence. Most of the time it is. Most of the time is an oversight or lack of knowledge, but no intent to harm anyone. But in this instant, it is a human rights violation, in my opinion. So do look into that, especially in civil law systems, because you're under the European Convention of Human Rights, which is very progressive and protective. So I am going to try to load up this. I'm not very technologically informed. I'm going to
you on your
try
neck.
to share.
You see, it says share screen. Get your
Yeah.
screen, your slides up on your screen, and then press share screen.
Okay, so desktop one on.
And don't forget the participants. You can put in your own question into the Q&A anytime you want.
So here we go. Just a disclaimer, this is for informational purposes. It's not legal advice. If you need legal advice, you should consult a lawyer. I'm just hoping to introduce legal concepts that you should be familiar with in order to have a better conversation with a lawyer with whom you might consult. Because there's a lot of legalese, if you will, out there and legal system, and it helps to understand it. So the judicial system in the US, we have two parallel systems. We have the state system, the federal system. There are three levels. It's the trial court, it goes to appeal, and then the Supreme Court. The federal Supreme Court, the US Supreme Court, has discretion in whether or not it will hear a case. So it's not an automatic right to appeal a case to well, you can appeal it, but it may not be heard. So there's discretion in that. If you are in Europe and your case has been properly argued under the European Convention of Human Rights, you have a right of appeal to the European Court of Human Rights. But it is important to argue those issues in your national case in order to preserve the issue or the question for the European Court. Now, some features that is of the legal system and of working with law that is really important to understand. One is that law is not black and white. We cannot really give yes or no answers most of the time. It involves a lot of judgment and evaluation, and different people can have different judgment and evaluate the same set of facts differently, because law is subject to interpretation and it is very fact dependent. And once you start the legal process, it's always possible that you find surprising facts that you weren't aware of or you did not anticipate to come to surface. It is very hard to predict how judges might rule on a case, even though there is kind of this assessment that the judiciary has been politicized and that some judges are more conservative and some are more liberal. Nonetheless, it is still difficult to know. You cannot be certain that a judge is going to be favorable to your client and your position. Same for juries. Juries, it's really trying to bring common sense into the legal process in the US. So it's hard to know what the ordinary person untrained in psychology, medicine, and law, how are they going to evaluate a complex set of facts? In European systems, you don't have the jury, so you just need to deal with the judge. And in my view, these cases are perhaps better off before judges, but I know not all of my colleagues agree with that view. And in the US, you do not have a right to have a trial by judge. You have a right to trial by jury. A trial by judge is possible only if both parties agree. And another important thing to know is that there is inconsistency of how the law is applied among jurisdictions. And that's just talking about federal law applied differently by different jurisdictions within the US. State law, just each state has its own laws. Again, there's commonality, but there can also be pretty big differences. So for these reasons, litigation outcome is very uncertain. Run from any lawyer who tries to assure you that your case is a good one, because we just don't know. It's uncertain for these reasons that we just talked about. There's lack of clarity. Now, what is the cause of action? This is just covering some legal language that would be helpful to know before you get into a conversation with a lawyer. What's the cause of action? It's when you have a situation, a factual situation that gives you the right to sue, that creates a reason for you to sue, to seek a remedy, to seek damages or compensation. In context of transition harm, there are different legal theories that have been put forth so far to assert the rights of detransitioners. So we are going to take a quick look as to what these theories, these causes of action are. The very first one and the most obvious one is personal injury or medical malpractice, which means there has been negligence, there has been a duty. Physicians always have a duty towards their patients. If that duty is breached by violating the standard of care, then they are liable for that harm. Informed consent is also an element of personal injury and medical malpractice. Physicians have an obligation to obtain informed consent. What does that mean? There are different standards in different states, so I cannot give you one single definition that's going to be good everywhere. But in general, any information that is material to the decision-making process about risks, benefits, alternative care, should be disclosed to the patient. And the physician needs to make sure that the patient actually understood. So that the patient needs to have decisional capacity to understand and process the information disclosed. That is different. This capacity is different from issue of competence. Doesn't mean a person is incompetent. A person can be very competent in making a vast range of decisions, but not be competent to understand this particular set of information. And it's the physician's responsibility to assess that. It is a subjective process, and it does have certain elements such as understanding the patient's expectations, values, rationality, but it's not something very black and white, because it involves exercise of judgment and an evaluation of physician-patient relationship. But the more complex the procedure, the more there is need for disclosure and assessment of capacity. And these are all questions of state law. So we have 50 states, and there is a diversity of standards of how these concepts are applied. There are lawsuits that have been filed on the theory of fraud. Fraud is just intentional misrepresentation or unfair trade practices vis-a-vis competitors by making a misrepresentation. And this is a question of state law. So we have some cases out there right now that have made the argument that these physicians and clinics have engaged in intentional misrepresentation of what the diagnosis, what the accurate diagnosis is and what the accurate treatment is and the outcome that they can achieve for their patients. Civil rights. So this is what I mentioned at the beginning. Civil rights protect immutable characteristics. What is an immutable characteristic in this context? Sex and sexual orientation. So that is perhaps the most relevant characteristic in this context, to argue that there has been discrimination or harm directed at gays and lesbians. There are also other rights. These rights are perhaps can be more strongly asserted in civil rights jurisdictions and should apply well to children or individuals who transitioned as children. And that is right to privacy and right to free development of personality. I won't get into technicalities of how they work differently in a civil law system and how that works differently under the US Constitution, because it will take us way off track. But suffice it to say that these rights are out there and you should be aware of it and explore it with an appropriate lawyer. I think you will find that lawyers who don't practice civil rights may not be as open to discussing it. So you might need to actually search for a lawyer who is very familiar with these concepts, because these cases present a question of first impression. So it goes back to what we said at the beginning. It is uncertain and we do not know. All we can do is construct arguments and try to persuade judges that the arguments are correct. And okay, civil rights can be a question of federal law or state law, but in the US, it is not applicable to all defendants. Usually you need to have a connection with the state through state funding or state action. So that's another layer of complexity with these with civil rights cases. Other causes of action. I think lawyers need to get creative, and I think hopefully we can come up with additional causes of action. Why is it important to have these diversity of action? It's important because cases have different facts, but also because of time limitation. So statute of limitations, all systems of law have a statute of limitations. I think some civil law systems refer to it as the prescriptive period. What that does is to set a maximum amount of time within which a legal action can be initiated. If you're out of time, then nothing can be done. It's a pretty hard and fast rule. When does the clock begin to run? Usually it's when the injury occurs, but some jurisdictions recognize the discovery. It's called the discovery rule, which means if you were injured, but you didn't know that you were injured, then the clock should begin to run when you discover your injury. And some states have a statute of repose, and this is usually when they have the discovery period. And what the statute of repose says, if you discovered and you didn't act diligently within a certain period, your claim is extinguished. Also, if you discover after the statute of repose, that claim is extinguished. And the purpose of it is to reduce uncertainty. It's to really protect people who are engaged in various activities from surprise claims 10 years, 15 years later. And it's to promote diligence. So if people have been harmed or they think they have been harmed, they should be diligent in assessing their harm and seeking counsel. And there is also the idea that after too much time has gone by, memories fade, documents may be misplaced, and therefore the court cannot engage in an accurate process of accurate fact finding because the evidence has deteriorated in quality. Now, as I mentioned at the beginning, the statute of limitation varies among states, between the state and federal, and it's different for different causes of action. So it's good to be aware of that. So if someone says you're out of time for what? For what cause of action you are out of time, and always inquire about the discovery period. Remedies. Remedies are the type of damages you can ask for. Compensatory damages or actual damages, that's just the monetary loss. You lost a career, you lost the job, those are your monetary damages. You had to pay out of pocket to get medical care. That's your compensatory damages. There may be compensatory damages for physical and emotional harm, for psychological injury. These are quite difficult to assess and put a dollar amount on, and that becomes a challenge. Pain and suffering, emotional damages, that's just general pain and suffering. It's like, this is really stressful and it causes me general emotional damages. It's different from psychological injury. And then there are punitive and exemplary damages on top. Now, what's important to know about these damages is that all of them are not always available. Some states, for example, have passed laws that has completely taken away punitive damages, for example, or has placed a cap on either punitive damages or emotional damages. So be aware that there are different damages, but depending on your jurisdiction, it's important to inquire about what damages are actually available, and then how are they going to be assessed. And as I said, like anything that deals with psychological injury, loss of bodily parts, these are very difficult to put a number on. So this is, it really falls on your lawyer to make an evaluation and try to prove that. In a jury trial, usually it's sort of appealing to the jury's senses to get them to hand out a bigger judgment. Litigation process. It always begins with an investigation. So the lawyer considering taking on a case has to first investigate the case. And the investigation phase, it requires a review of all evidence that's available at that moment, which means mainly your medical records and your own testimony to your lawyer, the information you provide about yourself, your life, what led you to be in your current situation. That's part of the investigation. But also then researching and looking at the law to see how the law and the facts match up. And this process will take some time. It's not something that you can resolve in the first meeting with your lawyer or any lawyer. It's especially for these cases because they are complex and they're unprecedented. So the lawyer has to do a fair bit of thinking as well as research and review of medical records. These cases will require experts. It will require more than one expert. And the experts' involvement will be necessary upfront for two reasons. Some states require an affidavit to be signed by an expert before a personal injury lawsuit is filed. But even in the absence of that, making these legal arguments, to make these arguments properly, you need expert input because a solid understanding of the medical aspects of these treatments is necessary to make good legal arguments. Then there is filing. So the attorney will prepare a complaint, file the case, and serve notice on the defendants, and they will have an opportunity to respond after a period of time. Again, that's determined by each state, determines how much time defendants have to respond. And there will be a period of motion practice between the lawyers. This is usually technical. It's just arguing technical aspects of the law, and usually defendants try to argue that the case doesn't really have merit and it should not be heard. But this will turn mostly on legal arguments. And this period, it can also be used by defendants to cause delay, and delay tactic, unfortunately, is common. And then the case goes into discovery. Discovery is usually very limited in civil law jurisdictions. It is quite extensive in the US, where each side gets to request documents, can send out interrogatories, meaning written questions, or depose witnesses. That includes the plaintiff, plaintiff's family, perhaps, or friends, if they think it is relevant to discovering facts that can help them, or if you yourself plan to put someone on the stand, like a family member or a friend who can testify about what happened, all of those people can be deposed prior to going to trial. Expert witnesses will be deposed for sure. So this will take some time to go through this. The more complex the case or the more there is to cover, then usually the discovery period will be longer. Once discovery is finished, there is possibility for settlement. Of course, there's possibility for settlement all along in the case, but usually it becomes more realistic or solid after the discovery period. The reason is that the discovery period leads to uncovering facts. It gives each party a more complete picture of the information they need to have to argue their own positions and assess the strength and the weaknesses of the case. So at this point, at the end of discovery, usually judges get involved and they say, hey, why don't you consider mediation? Sometimes it's mandatory, and there will be negotiations for settlement. If those negotiations are not successful, the case goes to trial. In general, over 90% of cases settle. For these cases, at this time, it is hard to predict because there is no precedent, and it's possible that the defendants will want to take their chances in court. If a case is not successful at trial, it can be appealed. Either the defendant or the plaintiff can appeal the case. Questions of fact usually cannot be reviewed on appeal. There would have to be an error in the application of law in order to appeal. Now, some of you had submitted questions regarding discrimination in employment, so I decided to touch upon that. Discrimination in employment on the basis of sex, sexual orientation, and gender identity are prohibited. To prove that, you need to show that another similarly situated person in your workplace was treated differently. Similarly situated means someone of equal qualification and equal level of performance received better treatment. It can also be based on a stereotyping analysis. For example, if you're a man and you present very feminine, that would be stereotyping if that is the reason for the discrimination. Because of that is to say, if you can show that you were treated in a particular way because of your sex. Or if you can show malice, it usually has to be pretty obvious, like someone making an outright comment, derogatory comment, that might be proof of malice in discrimination. So those are the factors to kind of look for, but it is best to leave it to the lawyers to do the assessment because these cases are actually quite complex. In hiring, it is very difficult to prove discrimination in hiring. Discrimination is easier to prove when you're actually employed, but if you were not hired for a job that you applied for, it's just very difficult to come up with the evidence because employers have great discretion in who they hire, and they can always come up with a valid reason of why they hired a different person. In the US, you can go to federal court you might have a state remedies, and you can also go to the Equal Employment Opportunity Commission. That is a more administrative process. They do the investigation and make a determination. There is also prohibition on discrimination on the basis of disability. That's the Americans with Disabilities Act. So employers may not inquire about disability when hiring. So they should not ask you any medical questions during your job interview. Now, once you're hired, you have to be qualified for the job that you're hired for, and you have to be able to perform the essential functions of the job without any special accommodation. And once those requirements are met, if you have a history of disability that impairs your activities, you can ask for special accommodation from the employer, and the employer is obliged to accommodate, like giving you a schedule modification or reassigning you to a different position. And this is federal law. Many states have parallel requirements. And then you can also take it to the EEOC if you have concerns. Now, back to detransition cases and the medical cases. These cases are very challenging for several reasons. First one being a statute of limitations. It appears to be the greatest challenge because the statute of limitations for medical malpractice cases are usually quite short, anywhere from 2 to 5 years tops. Usually they're around 3 years in most jurisdictions. So, and because of the nature of the injury in transition care or transition medicine, individuals don't come forward. They don't realize the wrong. And by the time they realize and come forward, the statute of limitations has expired. And this is a huge challenge because it's very difficult to go against the statute of limitations. It's really not possible. It would be considered a frivolous action. The second challenge for medical cases is arbitration clauses in agreements that patients are often asked to sign when they seek medical care. It's most often used with large healthcare providers, such as Kaiser, for example, which says that if the patient has a complaint, they are forced to go into arbitration by the nature of that agreement. They cannot seek legal remedy in court. It is very, very difficult to overcome arbitration clauses and have a court declare them void. So then you're forced into arbitration, and arbitration in general is not favorable to the weaker party, unfortunately. And it is a closed process. It is a private process. It is supposed to be fair and neutral. Your lawyer should do all he or she can to protect your interests. But the perception of the arbitration process is that it is not, it does not provide the same opportunity for justice as the court does. And they also don't give out the awards they give is also lower than the award you would get from a jury or a judge. So those are drawbacks of arbitration. What is good about it, I guess, is that it's a lot faster than going through the legal process. So it's just a little less burdensome in a way. But the lawyer handling the case should have experience with that and should guide you through that process. I don't mean to say that the process is hopeless or that it would not bring you any justice. is just to say that it is slightly lopsided by its nature, and its nature is that it's a private process. Though it is subject to regulations. And the big challenge of these cases is that it's a novel controversy. Most lawyers don't understand it because, they watch the news and the news says this is great and the kids want it, they need it. And then they go to their office and someone complains and it's all confusing. To understand it, it takes time. The person has to take time and read, not the press, but to read medical literature, to really take time and listen. Lawyers are very busy and they usually kind of don't want to invest unless they are for some reason motivated to invest. So they just don't understand. It's new and it's complex. And because it is unprecedented, it creates a high level of legal uncertainty. We just don't know how it will go in court. Now, about lawyers, we are not warm and fuzzy people. We might be compassionate, but don't expect to see a big expression of it. It is the nature of the work. Lawyers spend most of their day in conflict with others. So even if there is a warm and fuzzy side, it's not likely to be expressed in context of work. What motivates lawyers? I'd like to say seeking justice, but that would be a very idealistic answer. There are lawyers motivated by that, but once you get into cases like fraud and personal injury and even some civil rights cases, lawyers want to make money. And they want to make money by putting in less rather than more, because cases are very time consuming and time intensive. So they look for lower hanging fruit for a case that's a little bit easier than harder. That's just kind of a cynical or a jaded view of the profession. It's not to say lawyers don't care about justice, but it's to say that in our society, everything has become a business. And so lawyers also have that business mindset. How much time do I have to put into this case? And what is the likelihood that I will get something out of this case? And that creates a challenge when you have a novel question of law, when you have an unprecedented situation. For these very reasons that I just discussed about what motivates lawyers, when you go to a lawyer in a bigger firm, say more than 5 or 6 lawyers, there is a committee, and a committee has to approve acceptance of the case. So you could have an individual lawyer who would like to take a case, even if pro bono, and not all law firms do pro bono, they still have to have the firm approve it. So there's a committee within the firm that reviews cases to assess the likelihood of success for that case. And they make a decision as to whether the firm should be involved in that case or not. Another relevant aspect of lawyers and law firms is the area of practice. Usually it's written on their website. If you meet with them, ask them about it, ask about their experience, what is their background, and what is the reason for their interest in your case. Now, fee arrangements. Ideally, many of these cases should be handled pro bono, but pro bono at the moment is being practiced by the nation's largest corporate law firms, and they are very much captured by the trans rights movement. So it is not very likely that they will also be providing services to detransitioners. And once we leave that particular class of law firms, unfortunately, I have seen very limited pro bono work being done. I could be wrong, but I just haven't seen it. I have asked for it of people I know, and the answer is no. So, but these cases, regardless of the type of, or regardless of the legal theory on which they are built, whether it's fraud or personal injury or civil rights, these cases should be handled on a contingent fee basis, not hourly. If you meet with a lawyer and he or she wants to charge you by the hour, it's the wrong firm and the wrong lawyer. So you should not pay. You might have to come up with some de minimis amount of money, like a few $1,000s to just cover initial expenses. But you should not pay for the lawyers, not unless the case is successful, in which case the lawyer should, the lawyer will take a percentage of the award of the judgment. That percentage can be anywhere from 30 to 40%. If it's larger than that, I would definitely ask around. I would also look into the state bar rules as to whether that's even allowed. Some states have a cap on the percentage that a lawyer can charge in a contingent fee arrangement. Okay, and your engagement letter, your engagement with the lawyer must always be in writing. It should be detailed, and you should understand it, even if it means that there's need to consult with yet another lawyer for the purpose of signing it. So don't hesitate to review, to ask questions. Don't take the agreement and just sign it because that's the lawyer. Understand every clause of that agreement. If it's in there, it's for a reason. Now, what to know when you go to speak with a lawyer? I think it would be helpful. This is what I ask when potential clients contact me. Make a chart of when, who, where, what. And you don't need to go into great detail, but it's important to know when certain events occurred from the start, when from the onset of gender dysphoria to the time to the period of detransition, and when you visited which doctor or which clinic, and where they were located, and just a few sentences about what happened, what was the event, diagnosis, prescription, surgery, letters for surgery, psychological evaluation, whatever it was, just a couple of lines. The reason for it is that it provides a very quick overview of very important facts for evaluating viability, basic viability, things like the statute of limitations, or is there a civil rights claim? What laws are these people subject to? What is the correct jurisdiction in which a lawsuit should be pursued? So this chart would just save everyone a lot of time if you make it and offer it. Be prepared to discuss sensitive information and answer questions. And as I said, it probably will not warm and fuzzy. Some lawyers will be more sensitive than others. Don't take it personally. It is nature of the profession. Be prepared to educate the lawyer. As I said, this is a complex issue and most lawyers are not well informed. I strongly advise collecting all of your medical records if you haven't already done. Your medical records should include intake forms, consent forms, surgery letters, psychological assessments. But don't give it to the lawyer unless he or she asks for it. But you should have them because it's just so important to have them available right away, because it takes time. From what I hear from people is that it takes time. You have to chase each piece of your records in some cases. So it's better to just have everything organized and available if it is requested. Um, if the lawyer says, oh, okay, I'm going to think about your case, ask them to tell you who to contact so you can follow up, how you should follow up, and what is the timeline? How long are they going to take to make this decision? And hold them to it. And if your case is declined, ask for an explanation. You want to know what legal theory they considered. Was it a case for fraud, for civil rights, for personal injury, something else? What was it and why? Make them be specific. And don't give up. Don't give up quickly, and because you need to understand what happened. A lawyer who is just looking at your case as a personal injury claim likely has not considered whether or not you have a civil rights claim or a fraud claim. So you want to know why it was declined, and don't give up and seek out a different lawyer, either for a different legal theory or perhaps even the same theory, because as I said, law is subject to interpretation. One lawyer may think, this is not something I want to deal with, too uncertain, or something not clear. Another lawyer might say, it's not clear, but I'm willing to take the risk. So don't give up quickly. It's part of the game. Even if you had a different type of case, a different situation, it is normal to have to seek out different lawyers, because different lawyers have different criteria for what they do and what clients and what type of cases they take. Now, once you have obtained representation, again, you want to know who your point of contact is. You want to have an understanding of the timeline of your case. Be prepared. It will take time for the complaint to be prepared and filed, but do ask for a timeline of how long that's going to take. Lawyers usually tend to leave it to last minute. So if if you have a fair bit of time on the statute, they might not do it right away. You can discuss with them if they can expedite that. What else? You have a right, and you should insist on receiving timely updates on your case. Once your case is filed, it will move periodically. Things will not happen very quickly because defendants have time to respond. Then your lawyer has right and time to respond. And these times are at least 20 days, sometimes 30 days. So, but you should be informed every step of the way of what has happened. You know, what did the defendant say? What are they seeking? What's the motion about? How does your lawyer plan to respond? Even if it's a lot of legalese at that stage, and you may not necessarily understand all the finer points of law, it doesn't matter. You should be informed, and it should be explained to you in a way that you can understand basically what's happening with your case. And you will have a contractual obligation to be responsive to your lawyer. Don't expect your lawyer to chase you. You receive communication, whether it's a voicemail, email, phone call. It is very important to be prompt and respond. If a lawyer requests information, documentation, be on it as fast as you can. Lawyers will not chase you. They might follow up once, they will not follow up twice, and after that, they will drop the case. So, and this will be most likely in your agreement with the lawyer. And usually in those cases, lawyers will send out a bill for the time they had spent on it up to that point. Because when a lawyer takes a case on a contingent fee basis, the lawyer is making an investment of his or her time into the case. So there is an expectation that you cooperate. If you don't cooperate, the lawyer has wasted their time. They will drop the case. They will lose confidence that they have a credible client, and they will drop the case and they will send you a bill for the time. So, oh, and a note for individuals who are in the civil law jurisdictions, contingent fee is not always available in civil rights cases. So it might vary from jurisdiction to jurisdiction. It is available, generally speaking, in common law jurisdictions. And be prepared. Litigation is stressful. It goes on for a long time, so you have to be patient. And the side effect of it is that it causes a lot of anxiety for anyone, any person. Being involved in litigation is a stressful experience because you're being questioned by your own lawyer, by the other side, and you constantly need to support what you say. And then you have to wait. You have to wait. There are long waits. There are long pauses in cases where nothing is happening and you just sit there and wait and you don't know. Because when the judge has to rule and answer a legal question, there is no deadline for the judge. You don't know. You just have to wait. The judge will let you know when the judge gets to it. It could be 30 days. It could be a year. And you have to be ready for that and be able to distract yourself from it. You can't obsess with it. It will drive you crazy. So that was the presentation. I feel like I talked a lot.
You certainly did, but it was very, very interesting. I love the warm and fuzzy bit. I'm glad you put it because I actually think people do get put off by the lack. I do anyway, so I'm sure I'm not alone in the lack. I've been to lawyers and I'm like, it's like talking to a steel lamppost, and I'm talking about a serious event in my life that I'm really worried about, and they're just po-faced. And I love that you said don't give up. I do think anybody who's had the bravery and courage to detransition is already an extraordinary person with a lot of gumption. And so that they in many ways, there's something about that personality type who would be able to not give up and to take these cases. But as Lynn said earlier, you will, having gone through the trauma of detransition, to take a case, you will need support to help yourself through this. This isn't minor. Of course, Beyond Trans offers support, and there's lots of other ways to get support. No more than friendships, family, art, literature, music. There's a lot of ways to get support for yourself. Will we look at some of the questions that has been prepared already, Mitra, that you could maybe comment on, or would you? I don't think there's any questions in the Q&A. No, there doesn't seem to be. Is there anything else you want to comment on about it? And maybe will we stop the share? Just stop the share screen. Unless, Lynn, you might have any questions about it. I thought it was I didn't think I'd be interested because I'm not a lawyerly person, but actually I found myself much more interested than I thought I'd be. There might be a stop share somewhere.
I'm trying to find that. Let's see.
Maybe you don't need to. I think it's a kind of a handy slide to have up there. One question I would have, Mitra, is what are the pitfalls, do you think, that people that you've noticed, especially people with detransition? My own view is they fall at the first fence. If you follow me, they think there's no case because one lawyer said no. What are the pitfalls you've seen maybe among detransitioners?
I think really that's the big one. They give up quickly because they are not aware that lawyers can have different approaches.
Yeah.
Lawyers think differently, and there's a lot of judgment and somewhat subjective judgment that goes into evaluating cases. So I know I talked a lot. I tried to cover a lot of ground, but I hope becoming more familiar with legal concepts and understanding what causes these cases to be complex, helps in encouraging detransitioners to be persistent, because then they understand why a case might be rejected, that it's not personal, it's just that lawyer and how that person is looking at a set of facts.
And
And
my impression from detransitioners is that they think the statute of limitations is over. There's nothing I can do. Is there any give on that?
no, statute of limitations is very hard and fast, and it cannot be challenged. But the different causes of action are subject to different statute of limitations. So again, that's why it's important to understand what legal theory was the lawyer considering when they said the statute of limitations has expired.
Yeah, I saw you say that in the presentation, and I thought I didn't know that because I've heard loads of detransitioners over the years say to me, "So it's statute of limitations has ran out," and I've just, as a non-lawyer, went, "Oh," not realizing the vital second part of that sentence. Which statute of limitations for which case?
Right. Right. Usually, I mean, as I said, the natural inclination of anyone is to go for medical malpractice on these cases. And those medical malpractice claims are subject to a very short statute of limitations. So if that's the advice they have sought, and that's what they have been told, because usually by the time the person detransitions, it is out of that time frame. But there are other ways.
Just say
I
the
have
other
a
way.
question.
Just before Lynn jumps in, and you do jump in, could you just say what are the other ways? I know you said in the presentation, but just to kind of drive it home, what are the other ways that they would have other than medical malpractice?
Okay, so let me back up a little bit, because even on medical malpractice, there is always a question of whether there is a discovery period or not. Okay, so not all states have discovery, so that's an issue. But there are states that have discovery. But what the lawyer needs to understand, and I am learning that not all lawyers understand, is that discovery should be measured from the point of detransition, because it's a psychological shift. And we are talking about a psychological case. But if the lawyers measure it from a physical time, like the first time you got sick from your medication or something like that, then the discovery period also may not be helpful. So there's a lot of judgment, and again, different lawyers will evaluate it differently. But some states have a discovery period, and that can come in handy. Now, having said that, let's say if you have a 2-year statute of limitation to bring a claim from the time of injury, and then you have a discovery period. The discovery period is not forever, usually. It's say 3 years from the time of discovery. So if you have discovered it, but you kind of haven't acted on it, and just kind of sit around, it's not helpful for that. In terms of other causes of action, there's fraud and there's civil rights, as far as we know today. Hopefully, I'm hoping that there will be a creative lawyer somewhere who will come up with a fourth theory. But
As in medical fraud or informed consent fraud, or
it's more fraud in, yes, it's a combination. So I'm not the lawyer who has come up with that theory. But it's a combination that you're presenting a case and a treatment and a possibility of healing that is fraudulent, that it has no basis. It's fraudulent to tell someone or make someone believe that they can change sex, or to make them believe that having gender affirming care will treat their issues, say, related to autism spectrum disorder. So this can be a fraudulent misrepresentation in the practice of medicine.
wow, brilliant. And Lynn, I think you have a question there.
Yes, so I'm wondering about statute of limitations. So say that my statute of limitations has only another year, another 6 months. does my case have to be completed within that time, or do I have to file within that time?
You have to file
Do you
within
understand my question?
Yes.
Okay, so it's
No,
like as long as you filed, now you're within the statute of limitations. Your case doesn't have to be completed before it's up. It just has to be
correct.
filed before it's up. Is that right?
Correct. Correct. Yeah.
I think that's a really important question, and
Yeah.
I wasn't clear on it, so I'm pretty sure maybe I'm not the only one.
Yeah.
Yeah.
And there was something you said, Mitra, that I thought was interesting, which was kind of have patience with the fact that the lawyers are used to kind of, I was in a car accident, kind of, fairly simple, straight cases. Well, you're coming into these lawyers, we're coming into these lawyers with completely new concepts. So they mightn't jump quickly. They might go, oh, this is just way out of my league. I don't know what I'm talking. I don't know. That doesn't mean they won't bite. It just means that there has to be a certain level of patience, and then you can move on. But there does you kind of gave me some kind of empathy into what their position is. They're just shuffling papers, going, "What? What happened? I don't understand. Sorry." And they'll
Right.
just feel like they're out of their depth so fast. And I suppose if the detransitioner says, I'll walk you through this slowly, I'll give you a couple of bullet points about what's happened, and I can supply extra information, they might bite, they might go for it.
They might. It depends on the lawyer. If they have curiosity, if they have interest, they should listen. I think most lawyers should be professional enough to listen. But yes, it takes explanation and education of what this phenomena is about. You know, why someone has why someone starts to have gender dysphoria, and how comorbidities interact with that, and how there is this medical approach of not examining comorbidities, and how, excuse me, how transition is irreversible. Some lawyers may not understand why someone who says they regret their transition or are unhappy with the medical harm they have experienced have not changed their appearance, but they may not understand that it may not be possible to change their appearance, right? So it's important to explain these things, even though if a person has been working with these issues for a while, it might seem like obvious basic information. If a lawyer is not very familiar, it won't be basic to them. They will be just making some assumptions in their mind, and it's important to clarify it for them.
Great.
So,
Okay, I think that's everything. Unless anybody else has any questions, I think we got through a lot. Thank you, Rita. You'll be tired after this.
yeah, actually, there are some questions that were sent in that I didn't cover, and I'd like to cover them
Okay,
quickly.
we'll go to them now. I do want to just put in, just for my own sake, because I've been speaking with a lot of detransitioners over the years, that like some lawyers might be ideological, they might be religious, and they might not be in favor, for example, of gay, lesbian, and bisexual people's rights. And if that was your case, if you thought that was your lawyer and you're gay, you'd probably be better off getting a different lawyer, if you follow me, because some lawyers are ideological, some lawyers aren't. And you need to know that your lawyer is in your corner and understands your burden and and I'm not saying being gay is a burden, but like it understands your challenge, understands your argument as such. So I just wanted to get that in. Do you want to attend to those questions, Mitra?
Right. So I think the issue of being LGB had come up in the summary of comments and questions that were sent in, and I want to build on what you just said, and that is, LGB have a particular status within this phenomena, in that gays and lesbians, being gender non-conforming when they are young, are particularly susceptible to being pulled in to this phenomena. And this must be understood. And it has been understood historically, and that's the irony of it, and what is maddening about it is that it has always been known that gay and lesbian children are gender non-conforming. But now we disregard that as an attribute of being gay or lesbian, and they just treat them as if they're trans. You see, so it creates a problem. It creates a significant conflict, and it is a violation of gay and lesbian civil rights, in my opinion. And in fact, I have a have a case pending in court arguing just that. So while I appreciate the point that gay and lesbian detransitioners don't necessarily want to politicize things or have political representation, they just want representation that understands them. Sexual orientation is very relevant to cases that involve gays and lesbians. So you cannot separate it. You can't say, well, I'm a detransitioner, but my sexual orientation is not relevant. I don't want to bring it in. It is relevant and it should be brought in. It should not necessarily be politicized, but it is a factor that has impacted the medical transition. So it cannot be disregarded. Okay, and sexual orientation is a protected characteristic, so it essentially creates a right. So be aware of that um, of that information when seeking a lawyer. People had asked about suing organizations like GLAAD. This is difficult. It's very difficult to sue these types of organizations. The reason is that what is the duty? These are organizations that are just out there and people join them because they want to. And they don't really have a particular duty to anyone. You know, in type of conspiracy theories, a very special set of facts would have to present itself to justify a lawsuit against WPATH or GLAAD or any of the organizations that are involved in promoting this. And I can't really even speculate what those set of facts would be. They would have to be presented, and then a lawyer would have to go, oh, well, there, maybe we can bring a lawsuit, just like the case against AAP. That has very unique set of facts that came up, and the lawyers went for it, and again, the outcome is quite uncertain. Similar facts may appear for WPATH, and then perhaps a lawsuit can be brought against WPATH on that basis, but we don't know. Suing organizations is very challenging because there's no basis for it. And people had asked about changing their name back to their birth name or one that is more consistent with their natal sex. There should be no limitation on changing your name. I think this is true both in the US and Europe. It is a 14th Amendment right. You can change your name. You can change your name as many times as you want. So I'm puzzled as to why you would face a challenge. In Europe, it is an identity right within the European Convention. I'm sure it's nationally recognized. Same in the US, it is, as I said, the 14th Amendment right to identity, and you can change your name. Changing of the sex marker, that is, I can't really comment on that because it's a question I've never looked into. I think you should be able to go back to it. It seems strange that you would not be able to assert your biological sex. Legal professionals, there is expression of dissatisfaction with legal professionals. I think they're just seeking low-hanging fruit. They have to think maybe a little bit too hard. The other thing is this usually should not be so complicated, like changing your name. It's something people do on their own most of the time. So it could be that they don't think that they're, like it's not worth their time. Like, oh, it's going to take me 3 hours to do this, and I just don't take a job that is that small. I can't imagine why this should be so complicated other than possible discriminatory motives. Let's see. Yeah, employment related questions. I think I covered that in the presentation. And financial constraints, I think we have covered that as well. So I hope this has been a useful introduction for detransitioners and anyone who is considering legal action.
Brilliant. It was really, really helpful, Mitra. I'd imagine we'll get more in the future, but I think this is going to be really good to have to record, you know, to put on the website, and so that people are available and that they know the information is available. Do you want to give how people will contact you, or will they can contact you through Beyond Trans if you like? Which would you prefer?
They can contact me through Beyond Trans. Also my email is well, I don't know which one is easier. My personal email is mnf, that's Mary Nancy Frank, 17@hotmail.com.
MNF at MNF, get it?
mnf17.
At hotmail.com, or else Beyond Trans. We'll be
Yeah.
delighted to pass on your details to anybody who contacts us. Thank you, Mitra, and thank you, Lynn. Have you anything last to say, either Lynn or Mitra?
No.
I just so appreciate I appreciate you, Mitra, and I learned some things, so that
Me
was
too.
really great.
Yeah, I learned a lot of things. I think you really clarified it, and thankfully you didn't use jargon that just made me want to feel like I was back in school. It was very understandable. So thanks, Mitra. Really, really helpful.
Oh, you're welcome. My pleasure.
Okay, thank you, everybody, and contact us if you have any further questions or anything. Bye now.
Bye-bye.
Bye.